Good afternoon. I'd like to commence by acknowledging that we meet on the land of the people of the Kulin Nation and pay my respects to their elders past and present and to their emerging elders also. I'd also like to acknowledge that those of you who are joining us virtually are sitting and working on the lands of Indigenous peoples across Australia and in some cases across the world. And we acknowledge their ownership of land also. And a particularly warm welcome to Indigenous students and Indigenous peoples who are with us today. Good afternoon and welcome. My name is Pip Nicholson. I'm the Dean of the Melbourne Law School, and it is an extraordinary pleasure to welcome you all to today's seminar, The Role of the Ombudsman, A New Age of Human Rights. Welcome to our students who are joining us here in person at Melbourne Law School in Parkville, and a very warm welcome to those of you who are joining us virtually as part of the Victoria Law Foundation's Law Week program. So heartfelt and warm welcomes to one and all. You will shortly hear from our speakers, Ms. Deborah Glass and Victorian Ombudsman, who will be followed by the Honourable Marilyn Warren, ACQC. After their presentations, Associate Professor Paula O'Brien of the school will be chairing questions from the audience wherever located. So we encourage questions from the audience in the auditorium, but also questions from our audience joining us online. As always, a few but very brief housekeeping matters. I am strongly encouraged to ask you all to turn your mobile phones off if you're in the auditorium. So please check and turn it off. And for those of you online, the chat function has been disabled, but the Q&A function is up and running, and we welcome your questions through that particular portal. Today's proceedings are being recorded and will be available shortly after the conclusion of the discussion that we're going to have this afternoon. So now let me turn to introduce our speakers. Ms. Deborah Glass was appointed to a 10-year term as Victorian Ombudsman in March 2014. Her office works to improve public administration by promoting fairness, integrity and respect for human rights. She holds a firm belief in the need for government decision makers to bring judgment, common sense and dignity to their roles. Ms. Glass was, in fact, raised in Melbourne and studied at Monash University. She practiced law briefly before leaving Australia, working for an investment bank in Switzerland and then moving to a career in financial services regulation in Hong Kong and London. She later became Commissioner of the Independent Police Complaints Commission of England and Wales, heading up criminal and misconduct investigations into police. In 2008, Ms. Glass was appointed Deputy Chair of the Independent Police Corruption Complaints Commission of England and Wales, and in 2012 was awarded an Order of the British Empire for her service. Ms. Glass is also on the board of the International Ombudsman Institute, which brings together over 190 ombudsman offices across the globe. A very warm welcome to you, Deborah. The Honourable Marilyn Warren, ACQC, is the former Chief Justice of Victoria, a position she held between 2003 and 2017, and a former Judge of the Supreme Court of Victoria, 1998 to 2003. At the time when Marilyn Warren stepped down from the Supreme Court, she was the longest serving of the then state and federal Chief Justices. And while serving on the bench, Marilyn sat in all jurisdictions, trial and appellate, and extensively in commercial cases. Marilyn Warren was also the Lieutenant Governor of Victoria from 2006 to 2017. She has held the position of chair of many institutions and bodies, including the Courts Council of Victoria, the Judicial Commission of Victoria, the Judicial College, the Victorian Law Foundation, the Council of Legal Education, and the Council of the Institute of Forensic Medicine. Marilyn joined the Victorian Bar in 1985, becoming Queen's Counsel in 1997, and she was admitted to practice in 1975, not so very long ago, I hasten to add. She presently sits as a domestic and international commercial arbitrator and is a member of the Dawson Chambers Senior Arbitrator Group at the Victorian Bar. We were fortunate enough indeed to host Marilyn Warren as Judge in Residence across 2020. She was kind enough to extend and stay with us for the full year, and many of you may well have met with her virtually, but it's a real pleasure to welcome you today in person, and I thank you for coming. I am delighted these two women are here today to share their insights, and I welcome Deborah Glass to the podium.
Greetings. Let me first add my acknowledgements that we are on the traditional lands of the people of the Kulin Nation here at the University of Melbourne, which is incredibly exciting. This land always was and always will be Aboriginal land. Wherever you're watching today, wherever you are around Victoria or Australia, you too are joining us from the traditional lands of our First Peoples. And let me acknowledge that it always was and always will be Aboriginal land. I can't tell you how exciting it is to see a real live audience. This is the first real live audience I have spoken to since March of last year. So, gosh, I think, well, we'll see how live you are when we get to the Q&A session. But yeah, we'll take that one step at a time. But it is really exciting to be here. So how many of you know, I'm going to do a quick show of hands from those who are in the live audience, what the Ombudsman does? How many of you done your homework? You don't count, you work for me. So that's not a great show. All right. Okay. It's not enough for the Dean to know what the Ombudsman does. But that's what we're here for. So I hope by the end of the session, you'll have a sense of what the Ombudsman does and the place the Ombudsman has in the broader justice system. So what I want to do today, really in a practical context, is explain, what the Ombudsman is, what we do, with a focus on human rights. It is a huge privilege to have the former Chief Justice as a discussant today. I will confess to you that it is slightly intimidating because I studied law many, many decades ago at the other place, as you have heard. And I have since then made it a habit to only read judgments with my name in the citation, of which there are a few, and indeed you presided over one of them, I believe. So there we are. So I will leave the law to my learned friend here, and I will, but I will, I hope, give you a sense of the role of the Ombudsman in that system. So I want to talk about my role as a constitutionally independent officer of Parliament. As you've heard, I was appointed to a 10-year term 7 years ago, or as I like to remind members of Parliament, that's 2.5 times the term of a government, so you better get used to me. But what I want to do is start with a very brief history lesson, because ombudsmen exist in a historical context, and people think the institution is quite recent, but actually it goes back thousands of years. And some might say the first ombudsman, in fact, was this character on your left, who was a tribune of the plebs. Where back in Roman times, the tribunes of the plebs acted as a check on the authority of the patricians in the Senate. And then we get to, our character in the middle there is the first ombudsman to use the term. He originated in Sweden, appointed in 1810. And the term loosely translates. Can anybody tell me what the term ombudsman loosely translates to? I'm going to quickly Google it, so I think I will just tell you. Broadly, defender of the people. So it stems from the Swedish defender of the people or parliamentary agent for justice, depending on your translations. So the concept goes back a very long way, but the first incarnation in the perhaps in the modern Commonwealth world that we think of, it goes back to 1962, much more recent, in New Zealand. And the quote I put up on the slide there comes from the Attorney General of the day, from the parliamentary debates around why have an ombudsman. And the point that he made, and I put this up, and I'll is around fundamentally the imbalance of power between the individual and the state. The purpose of the ombudsman is to provide a redress for ordinary citizens against the overreach of the state. And he goes on, and I haven't included this in the quote, but not so much the conscious or malicious abuses of power, but the genuine mistakes, misjudgments, and what may be termed unreasonable decisions, which are inevitable whenever power is exercised. So the rationale for the ombudsman goes back to that, and indeed that continues to this day. So here we are in Victoria. Here are my predecessors. I am the 5th Victorian Ombudsman, the 5th person to do the job. I'm the first woman to do in the role, as indeed, I believe, my friend was the first woman in hers. It took till 2014 to get a female ombudsman. And I was told when I came into the role, you've got some really big shoes to fill. And I said, well, that may be so, but I'm the first to do it in heels. At least as far as I know. So a little bit more about the historical context. Again, we hear the word ombudsman all the time, don't we? And we read about it all the time. There are so many ombudsmen who, what's the Victorian Ombudsman? Well, what are all these other ombudsmen that you might be reading about? Well, just a bit of an overview there. And I'm just going to skate over these because you can look at these in your own time. The core functions of the ombudsman have actually been much the same over the years, but what happens is that functions get added and taken away over the years. So what you can see here, for instance, is local councils weren't originally within jurisdiction and then they came into it. Police were originally in jurisdiction and then came out of it. That's now with IBAC. FOI at some point is in jurisdiction and then goes out. And industry ombudsmen are also set up as industries become privatised. So we have an energy and water ombudsman as the industries are privatised, telecommunications, and so on. So you can see there a sense of how they have developed over the years. The ombudsman, in fact, was the kind of quasi-anti-corruption body in Victoria until 2013, when IBAC, the Independent Broad-Based Anti-Corruption Commission, was established, and then took the serious corruption matters and the police jurisdiction with them, which personally I was very happy about because I spent quite long enough dealing with police in the UK. So a bit of what we do, so what does the ombudsman actually do? With all of these things I don't do, what do I do? Anybody aware that I have the powers of a royal commission? Does that surprise? Oh, good, I'm glad somebody knows, and I don't count you either. Does that surprise you? Well, if you're going to be the imbalance of power between the individual and the state, you need some powers, right? So, so the powers of a royal commission are actually a really important feature of parliamentary ombudsman in Australia. So I'm not going to go through my act, heaven forbid. I'll let you do that yourselves. But just a couple of points to draw to your attention, particularly relevant to today's topic. One of my powers is to investigate whether administrative actions are compatible, or is it incompatible with a human right set out in the Charter. So I can investigate, essentially, whether actions are compatible with Charter rights. But my principal functions are basically to investigate, to inquire, to resolve complaints. And I have the discretion to do all of those on my own motion. So I've got a pretty nice set of powers, actually. They're pretty good. I complain about many things, but I'm not complaining about those. And I can form an opinion, and this will be relevant to something we're going to be talking about shortly, that administrative action was taken contrary to law, was unreasonable, or was wrong. And I particularly love the unreasonable and wrong. Because many things in life may be lawful, but they're still wrong, aren't they? So just hold that thought for a moment as we talk about some of the examples of cases. So quickly, just looking at some of my examples, some of my main functions, and some of these you may have heard of, and some of them you won't. I investigate complaints. That's a core function of any ombudsman. And they could be an individual complaint. We get about 40,000 of them a year. Most of them you will not read about in headlines in the media. But it's an absolutely vital thing that the office does. I also deal with public interest disclosures. And again, I'm not going to say too much about those because it's a topic you'll find and when you read the Act, and you can look this up for yourselves. But these are the kinds of cases that, that sometimes end up in the media and result in those headlines usually starting Ombudsman slams. Whatever I'm slamming this time, it might be a dodgy principal who spent public money on something that he shouldn't. I also investigate systemic issues. I don't know how many of you saw a report I put out yesterday, which is looking at how local councils deal with ratepayers and financial hardship. That's a systemic issue. It was an own motion. And I think a really important issue, in this day and age of financial hardship potentially stemming from the impact of last year. And finally, in my main functions, I investigate referrals from Parliament. And I don't get a whole lot of those, but they tend to be pretty controversial. There was and in fact, going back to judgments with my name in the citation, one of the important issues that was that was aired in the last few years was around the Ombudsman's ability to investigate members of Parliament, not in my usual jurisdiction, but on a referral from Parliament. And Chief Justice Warren was one of the appeal justices who decided that. So thank you very much, Chief Justice. I'm very grateful for the wonderful things that Parliament has sent in my direction since then. Let me give you some further examples, including of some cases that don't necessarily make headlines, because I can talk about, this is what I do, but really it doesn't become real, does it, until we see some actual case studies. So this is a recent one, which was a complaint that came through last year during lockdown from a woman in a wheelchair who wanted to use the toilet while she was waiting for a COVID test. You might recall, for those of you who took COVID tests, there were quite long queues over there. There weren't any suitable testing facilities. There wasn't a bathroom available to her. She had to go home. And when she came back, she was told she had to go to the end of the queue. So she complained to my office. We made inquiries with the department. And I'm happy to say that not only do they fix it for the future, but they acknowledge the systemic issue around that in future, what should happen is that somebody in discomfort, in distress, in the queue would be able to return to their place. So this is just an illustration of this was not an investigation. It was it was an important complaint, but a relatively straightforward matter that was resolved with a phone call that had consequences for many, many more people. So that's an example of the sort of thing we do. Another example relates to what you might refer to as my slamming jurisdiction, when I am, critical of individuals or agencies that come to me, usually from IBAC, as public interest disclosures. This is an example of a whole bunch of headlines that if you lived in Warrnambool, you would have seen in the Warrnambool region about the local council. So it was a lot of commentary about misuse and abuse of corporate credit cards. So certainly a huge matter of local public concern, and allegations being made about not only abuse being rife, but cover up by senior management. So when we investigated, we found out it wasn't quite what was alleged. In fact, it was in the barrel there was one particularly unscrupulous bad apple, but they weren't all spoiled. But in fact, and I put out a public report on that. And one of the points I made in that report was it doesn't actually take much to taint a reputation for integrity, and that agencies need to be as alert to these issues and to the perception of these issues as to the reality of misconduct. So it's integrity can be as much perception as reality. And who wants to be held accountable for mistakes you haven't made? I mean, it is enough to be held accountable for the ones you have. So turning again to some other recent, anybody see some of the coverage in relation to the Business Support Fund that came out? Let me see whether the video plays. I'm hoping it will. The COVID-19 lockdowns fell like a hammer blow on small businesses. To the Victorian Government's credit, it swiftly announced an economic survival package to provide $10,000 grants to eligible small business owners. The fund was established and scaled at speed, but soon after, my office was inundated with complaints. The department had 9 days to implement the program, but it missed some of the key checks and balances that would have picked up the inevitable flaws. And now, as a result of my investigation, about 12,000 business owners may be able to reapply to the fund. That's potentially over $100 million going back into the small business community. Sometimes it takes the nudge of the Ombudsman's elbow to encourage public servants to do the right thing. In the end, that they do the right thing is what matters. Know anybody affected by that? 12,000 people get to reapply to the business support fund that was handing out $10,000 in grants to businesses affected. And what this was about was good intentions getting lost in translation. So it was, people made typos in their applications. But I put that as an illustration because it is about slightly tongue-in-cheek. I talk about the nudge of the Ombudsman's elbow. What I'm talking about is the persuasive powers of the office, and which can be a pretty powerful tool for getting government to treat people fairly. And I hope in the discussion we'll have an opportunity to explore some of the difference in those powers. Turning to my human rights jurisdiction, and there's a few quotes, but you can find them on the website. I want to focus on a couple of areas here. I want to talk about OPCAT. Anybody here heard of the term OPCAT? Know what it means? I'm glad to see some nods. For those who are not familiar, it's the optional protocol for the Convention Against Torture and Inhuman or Degrading Treatment. And it is a United Nations treaty. It's a protocol that Australia signed up to a few years ago. And it's an unusually practical protocol because it requires signatories to open their closed environments to independent inspection. And it's a particularly, so OPCAT is something that everybody in Australia should know about, I think, and should be aware of the importance of it. So as I have the power to do this, even though I don't have a specific function under OPCAT, what I did was look into what it would take for an OPCAT compliant inspection to take place in Victoria. What would that look like? And I've done a couple of OPCAT compliant inspections, one of the main women's prison. And again, these are all reports you can read on our website. I'm not going to go into detail about them. But this is a quote, for example, that came out in that particular work. We found numerous really quite disturbing things, including a really high use of force and restraint. In fact, the second highest across Victoria's 15 prisons. And this is the women's prison we're talking about here. So that that I think is quite a disturbing finding. And routine strip searching of women before and after contact visits, again, particularly disturbing, bearing in mind that so many women in prison have been the victims of sexual abuse. So strip searching is a particularly inappropriate action unless really, really necessary. And in many, many cases, it simply wasn't. So a very quick skate over on some of the other reports connected to that. I looked at, when we were at Dame Phyllis Frost, the women's prison, we encountered the case of a woman who was unfit to stand trial, who had been incarcerated up to 23, locked up, essentially in solitary confinement, up to 23 hours a day for about 18 months. And I described that in my report, the one I tabled afterwards, as the saddest case I had seen in my time as Ombudsman. This, for me, shone a really disturbing light on people who fall into the gap between mental health and disability, and essentially that we have no facilities in Victoria for that are both secure and therapeutic for people with her condition. And finally, the OPCAT report that I put out most recently, which also generated a few quite disturbing headlines, and which has some direct connotations to the certain children cases that I'm sure you have all read as part of your studies, was on solitary confinement of children and young people. And we're looking at 3 different facilities: secure welfare, youth justice, and an adult prison, about the practices that applied in relation to young people under the age of 25. And looking at solitary confinement, which they don't use that term, by the way, in any of the literature or any of the guidance in Victoria, but they do it anyway, was one of the things we found. So it was particularly disturbing, and particularly in adult prisons, we found the lack of support and the lack of understanding for what drives young people to react the way they do, and the way they were handled in an extraordinarily untherapeutic way, in ways that were going to, in fact, damage them further, was something that was a particular concern. So I'm awaiting the government's decision as to who will actually inspect closed environments under OPCAT and other responses to my recommendations. But I wanted to give you a little snapshot of the kind of work that we do involving prisons and in relation to OPCAT while we wait for broader developments around under that treaty. I'm now going to finally turn to the public housing report, which I'm hoping that you're all very excited about, and I'm hoping you're all familiar with. It was as part of the set reading for the for the term. If not, it should be. You'll find it online, and I can see that your lecturer is going to put it on the examination papers. So I would. It's a really good read. It's a really good read. So I would encourage you to do it. And I'm just going to give you a very quick explainer. Over the course of 2020, the people of Victoria have experienced extended stay-at-home orders and other restrictions in the fight against COVID-19. But from July the 4th, one group of Melburnians experienced a lockdown that was different to all others. These people, about 3,000 in total, were residents of high-rise public housing towers. The investigation learned that on the morning of July the 4th, senior health officials agreed the towers needed to be locked down to contain a worrying outbreak of the virus. The lockdown was enforced by large numbers of police, who were on site before the residents knew or understood what was happening. Many were initially without food, medication, and other supports. Residents at 8 of the 9 towers were detained in their homes for 5 days. The lockdown successfully stopped the spread of the virus at the towers, but in my opinion, its immediacy was not compatible with the residents' human rights, including the right to humane treatment when deprived of liberty, and therefore appeared to be contrary to Victorian law. So I thought I'll just take a little journey inside that investigation, give you a bit of a feeling for how we did it. And again, I would encourage you to read the report because it does have a lot of really good information in there. So, back to July last year. Remember July last year? It was pretty grim times, wasn't it? And we saw the beginning of the second wave. The weekend before this all happened, we were seeing. We were watching this unfold, and a couple of my investigators actually went down to the towers that weekend, talking to community advocates, talking to officials there, getting a feeling for what was going on. And I remember we came back to the office because nobody was in the office then. We had a lot of conversations over the weekend, and we decided at that point that it was one of those things that we either investigate now and quickly, or we don't do at all. And it was too important not to investigate. So I took the decision that we were going to investigate how people were being treated, how their human rights were being respected in that situation. So that was a hell of a challenge, I have to tell you. When we're all they're in lockdown, we're in lockdown. Nobody can talk to anyone other than online and on Zoom. We all got really a bit tired of that. So we got creative. We got leaflets in community languages. We had lots of Zoom meetings with community legal centres. And we heard a lot of really distressing stories, really, really distressing, including people who'd endured civil war and dictatorship, before moving to Australia, who were traumatised by suddenly finding, that their home surrounded by police and being unable to go out, and unable to get access to the medication that they needed to, for their own health. So it was, that was pretty obvious right from the start. We saw a lot of this playing out on the television screens in front of us, didn't we? But in the investigation itself, one of the things we were keen to do is understand the decision-making behind this, this hard lockdown. So we interviewed, again, online, quite a few people. So the question we wanted, we were asking is, who made this decision to lock down to lock down the towers without any notice? There had been numerous lockdowns throughout Victoria, all of them with some notice, all of them. So we interviewed a number of people. It wasn't the decision of the Deputy Commander, it wasn't the decision of the Emergency Management Commissioner, who couldn't recall, it wasn't the Acting Chief Health Officer on the day, or the Secretary of DHHS, or the Operational Commander. And the Acting Chief Health Officer also told us it was the shortest time she had ever had to consider a human rights assessment. Essentially, the papers were given to her as she was on her way to join the Premier at a press conference. So who made the decision? Well, I wrote to the Premier to ask if he would provide me with his cabinet and confidence documents, and declined. So he's not obliged to provide them. That is a provision under my act that he is not obliged to give me cabinet in confidence material. He didn't, so there we are. He did provide it to the Hotel Quarantine Inquiry, which is why I framed it in my letter. You've given it to one inquiry, maybe you can give it to mine. But there we are. In the end, what I found was that the immediacy of the lockdown was not based on direct public health advice, and therefore, in my view, was contrary to law, specifically Section 38(1 of our Charter of Human Rights and Responsibilities Act. And my point was that it wasn't the lockdown itself, it was that would have been unlawful. A lockdown would have been okay, provided that it was the decision to lock down without any warning whatsoever. Now, my conclusion that the lockdown was contrary to law had a very predictable response from the government. It didn't surprise me, they did not accept that. I did make a point that I'm not expecting them to apologise for keeping us safe, and they rather predictably said, we make no apology for saving people's lives. That's not what I said. Read the text, but there we are. Some things, but I think what this illustrates is where people see the human rights conversation and where they saw that in that very difficult time last year. And I think some things like human rights are more important than ever in a crisis. They define us, I think, as a society. And this is precisely the point where governments think that certain actions are acceptable, is when we have to say to them, actually, they're not. And for me, this was an illustration of speaking truth to power. That is, I can't enforce my recommendations. I did recommend that apology. I still think it's an incredibly important thing. I can't enforce it, and nor should I. A forced apology is worthless. But what it did do, of course, was generate quite a few headlines. It was obviously embarrassing. Those headlines went as far afield as the New York Times and Russia Today. First time I think I've been in either of those publications. There we are, and again, we can pick up this conversation in a moment. I'm just going to end on a very brief comparison between the Ombudsman and the courts, and I'm not going to say, I'm going to say the Ombudsman side of this, and I think I will leave the comparator to you, because we both consider human rights set out in the Charter. But obviously the court has to wait for matters to come to it. I can actually just decide on my own motion to investigate something, and my investigations are inquisitorial. So I can issue public reports. That's obviously the way that I get attention and traction. I don't make binding determinations. Again, my powers are of the persuasive variety. Because I actually think the most impactful powers are the ones you don't need to use because everybody knows you have them. Now, the courts use different tools when they consider the Charter, and I will say no more about those. just to sum up, the Ombudsman is part of that system of proportionate remedies available to people who think they've been treated unfairly. So we're part of a broad system, and sometimes we're the best option when, for example, the law can't help or you can't afford to go there. And sometimes things are lawful, but they're not fair. And I deal in the territory very often of what is lawful but not fair. So let me just put up my persuasive powers. My final quote, which comes from the Irish statesman Edmund Burke, is not what a lawyer tells me I may do, but what humanity, reason, and justice tell me I ought to do. It's the guiding principle of ombudsmen the world over, and I commend it to you. Thank you very much.
Good afternoon, everyone, and thank you, Professor Nicholson, the Dean, for such a warm welcome earlier. And I also embrace the acknowledgement to country and the original Indigenous owners of the land where we and others gather. At the outset, may I say we've been very fortunate and privileged this afternoon to hear from the Victorian Ombudsman, and I would agree entirely with her that the function of the Ombudsman is important and critical to our democracy, and the Ombudsman is in a very different, indeed exquisitely different position from courts. As a former judge, there are many times you know of facts of events out in the community, but you are powerless to deal with them unless the cases are brought into the court. Unlike some jurisdictions such as India, there the judges have what is called a public interest jurisdiction, and they are able, if they are dissatisfied with the way a bus service is being run, or indeed as to how Mr. Modi is operating under the COVID-19 problems in that country, the Supreme Court recently intervened and gave directions to government. But we don't have that power in Australia. But in addition to judges being confined to the cases that come before them, they are also confined as to the way in which the cases are presented. A judge cannot give directions a la Judge Judy or some of those terrible jurists, supposedly, we see sometimes, go away and find out this, go away and get that. It does not happen that way. It does not happen that way. I wish this afternoon, in the short time I have, is to respond to the Ombudsman's presentation by starting with the question, what was the consequence of her report on the treatment of the people in the residential towers? The report was made public. There were recommendations to government, but as she has pointed out, she had no power or authority to impose a sanction. That is where the courts come in. I was indeed alert to the comment by the Minister for Health at the press conference held shortly after the release of the Ombudsman's report. I repeat his statement, "We make no apology for saving lives." Now, was the Minister's comment political, ministerial, or was it consciously or unconsciously driving at something else? Had he had legal advice underpinned by the principle of proportionality? There could have been an option of legal action brought by those who wish to protect the rights of individuals in difficult situations. There could have been an application for injunctive relief in the Victorian Supreme Court. That would have involved, ordinarily, based on other cases, judicial review of the decision, looking at questions of reasonableness, rationality, logicality, all those things that the administrative law students are fully aware of. And also in these types of cases, there is added on or run in a dual way whether the rights of the individual under the Human Rights Charter has been breached. We know that in Victoria, at the time of the tower problems for the residents, we had the precedent of the certain children cluster of cases. For those not familiar with the case, it involved children held at the Youth Justice Centre at Parkville and later at Barwon. And there was judicial review brought in the Supreme Court. The case was heard separately, 2 occasions, by 2 Supreme Court justices, Justice Gard initially, and then secondly by Justice John Dixon. And the case also went to the Court of Appeal. The decisions of Justice Gard and the decision of Justice Dixon are binding authority in this state, they being 2 Supreme Court judges, and they held that the conduct of the Department of Health and Human Services breached the Charter. There are many similarities between the Certain Children case and the Towers case. Allow me to run through them very quickly. The orders in relation to the Towers were issued very, very quickly. They were indeed the most restrictive in Australia. 3,000 people were placed in custody. Prior to making the decision, the Department of Health and Human Services had not conducted an outbreak management plan, and as such, they were in breach of state and federal guidelines. Now, when I mention some of these things, the administrative law students might start to think about reasonableness, logicality, irrationality, those kinds of principles in administrative law. And when these decisions are made, they are capable of scrutiny and indeed attack under the basis of administrative law principles. The Towers set of circumstances came to light that the department officers thought they were going to have time, 36 hours, to implement all the measures necessary to support the residents. However, it was overtaken by the Cabinet subcommittee chaired by the Premier and then announced. The department, and indeed the Deputy Chief Health Officer, had 15 minutes to consider the Human Rights Charter obligations before the decision was published. Now, in the Court of Appeal, in the Certain Children case, we expressly stated that making decisions that had impact on the Human Rights Charter was not a box-ticking exercise. The question is, how could the Deputy Chief Health Officer make a decision in 15 minutes? There were potential defects in the decision, a disregard of the guidelines I've mentioned, box ticking of the Charter, insufficient departmental staff to run the occasion, insufficient briefing of departmental staff, delayed information to ESL residents, a lack of translation services, various restrictions didn't comply with the Public Health and Wellbeing Act. There was use of enforcement agencies. There was non-daily checking of residents. There was not daily checking as required under the relevant act. The urgent needs of the residents, such as medication, were not met or delayed. And the vulnerability of the particular cohort did not seem to be adequately considered. The Ombudsman delivered her report, but that did not come up or come to light until later in the year. So if we can cast back in time to July, when these events are happening to these poor people at the Towers, at that point, on the basis of the Certain Children cases, were there possible prospects? There would have been strategic and logistical difficulties with the Tower case, containment, deprivation of legal access, ESL and speed of lockdown and so on. It would have been very difficult to prepare that case in a space of a day or two, in some respects even in 24 hours, compared with what happened in certain children, where there had been, as I recall, a number of days before the case first entered the courts. We have in Victoria something of which we may be immensely proud. It is a strong pro bono tradition. We need only think of Justices Mortimer, now of the Federal Court, and Justice Jane Dixon of the Victorian Supreme Court, their work at the Victorian Bar, Matthew Elbert of the Victorian Bar, David Mann, well-known immigration lawyer, and then, of course, the Human Rights Law Centre under Hugh de Kretser. Why not? Why wasn't there litigation brought to try to help those people in the towers? I suspect the question may be answered with the term proportionality, and we will come back to that. There was an important case handed down subsequently, which helps us put the circumstances of certain children and the Flemington Towers into perspective. It is Loielo and Giles, a judgment of Justice Ganane of the Victorian Supreme Court, delivered on the 2nd of November 2020. There, His Honour had a judicial review case which raised matters under the Charter concerning the nighttime curfew that was introduced in September. It was very analogous in its presentation to the certain children claim, judicial review, the usual principles, unreasonableness, irrationality, illogicality, all those things that you are learning about in administrative law, and also the Charter and alleged breaches of the Charter. The difficulty in the Loielo case was that by the time the case came before His Honour Justice Ganane, the order that was the subject of the dispute had been revoked. I do urge the administrative law students to look at this judgment, because in an extremely powerful and articulate way, Justice Ganane sets out all the administrative law principles in a way that will be readily available and will help you understand the interaction and synergy between administrative law and human rights charter law, and how the two act interactively. In relation to the administrative law aspects, unreasonableness and so on, Justice Ganane found the order was proportionate to the public health risk sought to be prevented, that the decision was not made arbitrarily or without regard to minimum restriction requirement. He held that the department, the Deputy Chief Medical Officer had a public purpose and that her evidence was to be accepted. Now, this goes back to the way in which these cases are presented. Unlike in certain children, the plaintiff did not lead medical evidence or expert evidence to challenge what the state had done. The plaintiff in the Loielo case did not lead medical evidence to challenge the evidence of the Deputy Chief Health Officer. His Honour Justice Ganane accepted the evidence of the Deputy Chief Medical Officer. And hence the case failed under administrative law principles. Under the Human Rights Charter, there was reliance on the right of freedom of movement and the right to liberty and security of the person. Justice Ganane held the right to liberty was not invoked for reasons such as the plaintiff had some capacity to leave her home and conduct her business on a restricted basis. So again, there was a nuanced fact that is different from the residents of the towers who were in lockdown 24 hours a day for a number of days. Justice Ganane made comments, and again, please note those who read the judgment of paragraphs 217 to 220, where he cited an English case, the Secretary of State for the Home Department against JJ. This was a terrorist case. A curfew of 18 hours per day was imposed, effective solitary confinement. Now, the Privy Council said in their judgments that it was necessary to focus on the actual lives of the people affected. Or we need only reflect, having seen the Ombudsman's presentation, how the lives of the individuals were affected in the towers. Now, this case, again, before Justice Ganane, turned on the question of proportionality. His Honour noted, and this is very relevant in these sorts of cases, that the advice to the Deputy Chief Medical Officer was that modelling showed, in the absence of control measures, in the following 6 months, Victoria would see over 10,000 people die. That evidence was not challenged or rebutted. The advice given to the officer was also that if the then current rate of community transmission in Greater Melbourne persisted without restrictions, there wouldn't be enough contact tracing staff to cope, and infections would spiral out of control. It was also noted that Victoria was in a state of emergency and restriction measures had been effective thus far in reducing infections. And ultimately, Justice Ganane concluded that in the short time in the case before him, not the Tower case where there was 15 minutes, that the Deputy Chief Medical Officer did take account of human rights. But ultimately, Justice Ganane concluded that on the basis of proportionality, he would not make declarations or impose any restrictions in the particular case. So the Towers lockdown occurred in July. Loielo, before Justice Ganane, was heard in late September and October 2020. The judgment in that case was handed down on the 2nd of November, and the Ombudsman's report, as I understand it, was December 2020. The Loielo case and also certain children cases demonstrate the speed which is required for logistical and strategic planning, identification of relevant and expert witnesses, and the preparation of court documents, affidavits, and submissions. In the Tower case, we may postulate that time and the risk of proportionality arguments may have inhibited intervention. Remember, Justice Ganane, as a judge, faced the prospect that 10,000 people might die. I suggest there was an incomparable public risk compared with the public risk, that is law and order challenge, in the certain children cases when we compare certain children with the Tower case. It is likely a charter-based challenge in the Towers case would have been difficult as to the lockdown, not the treatment of the individuals. The statements of the English judges in the JJ case, especially Lady Hale, as to how people are detained would be a key. Now, the long-term answer for lawyers may lie in a class action in the Victorian Supreme Court, alleging a tortious breach and a claim for damages. The proceeding has been filed, and we wait to see where that takes us. Thank you.
So thank you very much. For those who don't know me, I'm Associate Professor Paula O'Brien from the Law School. Thank you to both Deborah and Marilyn for absolutely fantastic presentations that speak so well to what we have been covering in administrative law this semester. I could hear the tap, 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 tap away as everybody was taking notes. And so we're just a bit over time, but what I thought I'd do is we might take a few questions together so we can partly hear your thoughts and reflections on the presentations, and then we can have some short responses. And then you might have a chance also to come up and speak to Deborah and Marilyn afterwards. So would anyone like to ask a question of our speakers? Yes, Fang.
So I was quite interested in, so with the work of the Ombudsman, I guess inevitably the Ombudsman might get accused of being politically motivated. I was curious with just how you believe the ideal Ombudsman should sort of respond to these accusations of political motivation.
Well, I hope my reports speak for themselves. I'm certainly conscious of becoming, I wouldn't say enmeshed in the political fray, because actually I like to remain above it. But the point of the Ombudsman is to say things that are politically unpalatable sometimes. And I will tell it like it is. So if that offends those in power, well, so be it. And I would say that that's true of anybody in power, whichever side is in power. Ultimately, what the Ombudsman may well investigate is not go. The conclusions may well not suit them. But that is what speaking truth to power is about.
Could I just add to that? One case that the Ombudsman referred to, but didn't name, which I sat on in the Supreme Court, was the Red Shirts case, as it was known, and it raised the question of the Australian Labor Party using parliamentary staff for political purposes. Now, the Ombudsman took the case for particular reasons to the Supreme Court. She was certainly not intimidated or in any way restrained in investigating that matter and seeking to have powers clarified before the Supreme Court has already mentioned. But of course, there was a political consequence because the opposition in Victoria leapt on the Ombudsman's statements and indeed the judgment of the court and other aspects of it for political purposes. So sometimes in a public role, and indeed even in the judiciary, what you do can be utilised for political purposes, but that does not mean that the individual or the court or the Ombudsman is acting politically.
Thank you. So do we have another question from the audience? Yes, thank you.
Thank you so much for your time today. It was really fascinating talk. I'm just wondering how much pressure there is for Parliament to respond to and implement recommendations from the Ombudsman. Like, how much power do you think it has?
Well, I talked about the persuasive powers of the office, and I can tell you that my record in having recommendations implemented, because I produce a report on this every 2 years, is tracking at around about 96%. So not all of them, and I'm not very confident that I'm going to get that apology for the public housing residents somehow, but that might just stand as one of my few failures. But the power there, and I think this is a really important distinction with the courts, is one of exposure. You investigate and expose. So there's no particular remedy for those tower residents in my report. But what that investigation did was uncover the decision-making that sat behind the original decision. It uncovered that the person whose name was on the order was very uncomfortable with the decision that she signed, and that she didn't have enough time to consider the human rights assessments. And it puts evidence out there that can then be used in whatever context is appropriate, including in the courts.
And we'll take a final question from the room.
So courts and the Ombudsman both need to be independent from executive agencies, and obviously that's fundamental to the role of supervising and scrutinising the executive. Particularly in terms of the work of the Ombudsman, I'm wondering how you think about essentially your powers of persuasion and inability to compel executive agencies to operate in certain ways, in terms of the long-term strategy of maintaining a relationship with the agencies such that they are able to modify their policies and be more compliant?
That's a really good question. And it's one thing I thought about very hard when I came into the role. Wherever possible, I seek to make change through collaboration. with agencies. And this goes back to many, many years before I even came into the role, when I was dealing with overseeing the police in London, for example. Where if you want to achieve change, you have to take people with you. You know, if you can't just accuse the police of being racist and expect them to become less racist. You know, you actually have to get them to acknowledge that they have a problem that needs to be fixed. So I brought that attitude with me into this current role, and with something like the Business Support Fund that I showed you earlier, it was important to me to have the department acknowledge that it had been wrong in its decision making, and that's what happened. So again, it's a persuasive response as opposed to a directive one. So what I think was persuasive there was a report full of evidence that said, actually, the government's policy objective is to help people in crisis, and you're penalising them for making a typo in an application form. How does that achieve your policy objective? So having them acknowledge that and go, actually, right, you know, this is before the report comes out, I think we need to fix this one, is a collaborative measure. And some of this is, you know, frankly, how will this look?
Would you like to comment on that
Well,
finish?
in terms of the courts, we deliver our judgments and make orders. That is usually the end of the matter unless there is an appeal, and it is up to the successful party to utilise the judgment for their purposes. There's no interest in education or persuasion on the part of the judges delivering the judgment. They're deciding the case on the basis of the evidence and legal principles, a quite different role. But each of the Ombudsman and the courts play a vital part in our democratic structure, because the modern approach to government, more than ever, is seeing a very aggressive expansion of the utilisation of executive power. And institutions that were established to try to grapple with that, including the Ombudsman, that office over the years has encountered difficulty. Our current Ombudsman has overcome those, but freedom of information has largely been diluted as an effective tool because it is commonplace for cabinet incompetence to be claimed, as was mentioned by the Ombudsman with respect to the document that she asked from the Premier. And so the courts don't have a capacity. We don't have that public interest litigation power that I mentioned with India. So we can't of our own volition go and say, Premier, tell the Ombudsman or tell the hotel in quarantine inquiry who made the decision or how it was done. It's not the function. But together, we all form a structure. The modern difficulty is that there are now tensions developing, and our lawyers and roles such as the Ombudsman and the Commissioners for Privacy, the Commissioners for Information and so on must be very, very vigilant. And also the Academy plays a very important role. So for example, we've had Professor Rundle of this law school write excellent pieces revealing the problems of governments contracting out services, and therefore that becomes a measure to put those services beyond the reach of scrutiny, arguably the Ombudsman, certainly the courts and other integrity institutions.
Well, thank you both extraordinarily from Melbourne Law School and from the students of administrative law. I'm sure the students will agree it was absolutely fantastic session in terms of their studies this semester. And for everybody who's watching the live stream as part of Law Week, we hope it was a fantastic session as well for you. Could you join me in thanking our speakers very warmly for their contribution?